Good
This
afternoon,
honorable
Your
court
Honors.
is now in session.
All right. Thank you, gentlemen, for joining this afternoon for the Court of Appeals session. We appreciate you participating via Zoom. It's not our preferred method of conducting oral arguments, but obviously it's the safest way to conduct oral arguments. We will follow the same procedure and protocol as if we were in the courtroom today, which essentially means that each side will get 15 minutes to make its oral argument. If you're the appellant, you've reserved rebuttal time. You'll receive that rebuttal time as long as you have reserved it with the clerk. Before we get started, I want to introduce today's panel for you, or to you rather, Judge Thomas Skip Frierson from Morristown, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. Ms. Angie, anything we need to take up before we get started?
No, Your Honor.
If you'll call the case then, please.
Chimneyhill Condominium Association versus King Chow.
All right, we will hear from the appellant.
Well, good afternoon, Your Honors. I'm glad to be here participating today. My name is Mark Gray. I'm from Winchester Law Firm representing the appellant, King Chow. And I'll give you, and the Honors have probably already read the briefs, but I'll give you a brief background in the case. This case originated in General Sessions Court. The association, Chimneyhill, is a condominium association, and they were suing Mr. Chow for assessments allegedly owed. And Mr. Chow had filed a cross action, which is equivalent to a counterclaim in General Sessions Court. And they had their day in General Sessions Court, and the General Sessions Court entered a judgment for the association on October 19th, 2016, in the amount of $10,218.25. And there was no judgment given on Mr. Chow's counterclaim. Well, Mr. Chow appealed to the circuit court on October 28th. He timely appealed and drew Division 5. And then Mr. Chow almost immediately filed a motion to amend his pleadings in Sessions Court. And as Your Honors know, the General Sessions pleadings, are not too detailed. So he filed a motion to amend. That was granted. And Chimneyhill also filed a motion to amend its pleadings, and it was granted. And the parties proceeded to conduct discovery that was quite contentious and went on for some time. Well, the association filed a motion for summary judgment in February of 2019. And the court also set a trial date in May of 2019. Now, what happened on May 30th, the trial date, is not exactly clear in the record. And Your Honors, I apologize. I did not try the case. I'm just the appellant attorney. But we do know from the record that on May 30th, 2019, the association's motion for summary judgment was denied because there were issues of material fact, mainly about the contentions of the parties who breached first. So what happened is the court reset the trial. But in the meantime, the association filed yet another summary judgment motion, this one strictly for attorney's fees, even though they had not got to the conclusion of the trial. Well, again, the record is not exactly clear, but we do know that everybody showed up on January 15th of 2020 to hear the motion for partial summary judgment on attorney's fees. What happened at that motion is one of Mr. Chow's attorneys advised the circuit court that Mr. Chow was going to file a notice of dismissal of his appeal. The court excused the attorney to go file the notice, which he filed. And then when he came back, after advising the court that the notice of dismissal had been filed, the circuit court proceeded to hear argument on the summary judgment for attorney's fees and granted a judgment to the Association for Attorneys' Fees based on that summary judgment that previously been filed. Now, Your Honor, I'm going to keep this real simple. And again, if you've read my brief, it's a lot of repeating of what I've already said. But you know, Your Honor, I was looking at the case law on this. And in particular, there's a case by the name of Crowley versus Thomas, 343 Southwest 2nd, 32, Southwest 3rd, 32, a 2011 Tennessee Supreme Court case. And that case is frankly almost exactly on point with what we've got here in this case. And what Crowley basically held was very simply this: when the appellant files a notice of dismissal, that's the end of it. It's a jurisdictional thing. In other words, the appeal comes up pursuant to the Tennessee Code 27-5-107-108. And when the case is dismissed at the appellant's discretion, and he can do it with or without leave of the court, then the circuit court is supposed to simply affirm the judgment of the sessions court. What we had here is the judgment was not simply affirmed. The court went on after the notice of dismissal was filed, and the court acknowledges this in its order. They proceeded with the case basically to hear what amounts to the summary judgment would have been on Chimneyhill's amended complaint, so to speak. And I believe under the ruling of Crowley versus Thomas, Your Honors, that was an improper ruling. That once the case was dismissed by the appellant, this matter should have ended at that point. Now, I will point out to Your Honors that if the case had been appealed a few years later in 2018, it would have been a different result, because the law did change. In 2018, the statute changed. It basically said if one party appeals from Sessions Court, then anybody can bring up anything. Okay, but then that wasn't the law at the time that this appeal happened in 16. And in fact, the Crowley case talks about that, when what law applies, and it's the law at the time of the appeal applies. And my point is that Crowley required affirmation of the General Sessions Court judgment. It did not allow the court to simply go on and do more with the case after that time. So that's my argument in a nutshell. Yeah, I don't know. I'd be glad to answer any questions you have. Whatever you want to ask me about the case, but that is my legal argument.
Seeing none, we'll hear from the appellee.
Good afternoon, Your Honors.
Good afternoon.
Thomas Bloom here. I represent Chimneyhill Home Condominium Association along with co-counsel Christopher Coleman. Can you hear me okay? My voice is kind of low. Can you hear me okay?
Yes, we can hear you fine.
Well, you know, I would agree with Mr. Gray to the extent that if the Crowley case was on point, then this case would be over. But the point is that Crowley is not on point with this. It is really absolutely in opposite with this. And in this regard is this: in Crowley, you basically had a defendant. It was a car accident case, and a judgment was rendered against the defendant, and the defendant appealed that judgment as a liability issue. If now the plaintiff had gotten her judgment, if she had been dissatisfied with the amount or anything like that, she could have appealed, but she did not. She just went up. When it got up to the circuit court, she started amending her complaint to ask for more money. She had her chance to do that, and that was the issue in Sessions Court. It was essentially the same case. She was just trying to, add to the judgment. She added a party. Now, in this case, we have Chimneyhill. They got what they wanted in Sessions. They were not aggrieved. They had absolutely nothing to appeal. They could have walked away and been very happy with everything. Now, Mr. Chow did appeal. Now, what he appealed, he just appealed the judgment. He did not appeal the dismissal of his set-off or set-off a reimbursement for repairs that he had made to a roof. When he got up to circuit, he amended his, he amended his counterclaim to add this set-off. Now, at that point in time, at that point, Chimneyhill was required to respond. Part of their defense was, we did everything we could to repair your roof. And by the way, you also did that in breach of the master deed by not getting authority. You used, substandard shingles and whatnot, wrong colors. So it was entirely, in order for, according to Mr. Gray's argument, Chimneyhill would have had to file basically what would be a frivolous appeal or make something up. And they didn't. So I don't think Crowley has, anything, is totally an opposite. Chimneyhill was satisfied with the general session judgment. They had nothing to appeal. And, and when Chow amended his counterclaim in the circuit court to seek a set-off, Chimneyhill defended on the grounds that they attempted to address his concerns and that he had also made unauthorized repairs. Now,
I understand what you're saying, but the Crowley case doesn't make a distinction that you're making, does it?
Well, I think, Your Honor, I think the Crowley case is based on its facts. I think it's based on its facts, and our facts are different. Now, I think if Chimneyhill had basically come into circuit court and if Chimneyhill had come into circuit court and tried to increase their attorney fees that had already been expended, then it would be on point with Crowley. But
in your particular case, though, the Sessions Court hadn't awarded any attorney's fees, had they?
Yes, the Sessions Court awarded. They awarded attorney's fees and a judgment against Mr. Chow in the general sessions. That's what he was appealing.
Okay. But you were going to incur additional attorney's fees in any event because of the appeal of the appellant in this case in general sessions court, weren't you?
Yes, you would. But the question is, does that mean that you have to file, you have to basically file an appeal saying, since we're going up, I want my attorney's fees as well? I mean, that's sort of a given. I don't think you could file an appeal from general sessions court because of a contractual right for attorney's fees if you prevail. I'm going to submit some supplemental authority, and I'll just bring this to the court's attention.
Well, if you're going to submit it rather than
talk about it, just go ahead and
talk about it. Just send it to us, and be sure and copy opposing counsel.
Okay. Now, I would like to mention that the Tennessee Rules of Civil Procedure 4202 and 1309 may be applicable in this case. The case does go up de novo to the circuit court out of the general sessions, and as de novo, I think basically new issues can be brought up, and that the circuit court does not lose their jurisdiction as a result of Mr. Chow's decision to dismiss. I mean, you can see how unfair that could, absolutely be.
Well, isn't that why the legislature amended the statute?
I think they amended the statute to make it like your court is, the Court of Appeals is, that that if you have something to appeal out of general sessions, you don't have to do a second appeal. You can just come up and you can do a cross appeal.
But
That
you're
is
not
different.
suggesting at the time that this appeal was filed that that's the law, are you?
Correct, but it's not a cross appeal. No, it was not the law. I mean, it's in black and white. It wasn't until 2018. So I believe that the Crowley case did not rewrite the statute. They applied the statute to the facts at hand. And the facts at hand are, I mean, they're absolutely different. We did not have an aggrieved party. Chimneyhill was not aggrieved following the general sessions decision. Now, when they were brought up on this appeal, and Mr. Chow filed a new issue, set off in reimbursement, then they were required to defend themselves, and that did incur attorney's fees. And by their master deed, they certainly are entitled to it.
Well, let's talk about that for a moment then. If the only notice of appeal was filed by the appellant at circuit court, and the appellant dismisses that notice of appeal, and obviously your client has not filed a notice of appeal, and the only issue pending before the court is a motion for partial summary judgment, which I'm assuming was for the right to collect attorney's fees because you couldn't get the amount at that point in time. If the appellant has dismissed that appeal in circuit court, what is the jurisdiction remaining of the circuit court to make any decision on that?
The circuit court at that point has subject matter jurisdiction over Chimneyhill's counter complaint. It's continuing jurisdiction. It does not, everything does not, you just don't, Mr. Chow did not have the right just to pull the plug because there had been a de novo review, a counter complaint had been filed, an amended complaint had been filed, and that remained in the circuit court's jurisdiction.
Isn't that pretty much the same situation with Crowley?
No, it's totally different.
There weren't new claims that were filed in circuit court by both parties?
It was the same claim. The plaintiff in Crowley brought up the exact same claim that was done in general sessions. It was still amount of the judgment. It wasn't anything new. She just wanted more money. It was the very same case. And in our case, it's related to the case. I mean, Chimneyhill was required really to defend itself by bringing up these claims. So, I mean, factually, it's absolutely different. And I think maybe I explained it better in my brief. I hope so. But it's, when I first saw Crowley, to be honest with you, I was hired on the appeal with Mr. Coleman, and I saw Crowley and I said, uh-oh. But then when I looked at it, I mean, it's lawyers' jobs to distinguish cases given. This case is distinguished absolutely. Sometimes you distinguish a case and it's just kind of like, well, this might work. But I see absolutely no relationship between Crowley and what we've got here. It was a totally different cause of action, really, that they were bringing, which was really mostly defense in order to defend.
But I don't want to argue with you, Mr. Bloom, but
No,
I'm
that's
reading
fine.
Crowley. And it says, in the circuit court, Mr. Crowley filed a first amended complaint, adding his wife as a plaintiff. Wife wasn't a plaintiff in the general sessions cause. So that's a new cause of action there. A second amended complaint filed by the Crowleys asserted an additional claim. Ms. Thomas answered the Crowley's second amended complaint, moved for a more definite statement of damages. In the Crowley's third amended complaint, the Crowleys sought compensatory damages of $125,000. Ms. Thomas answered the third amended complaint. The Crowleys filed a fourth amended complaint seeking compensatory damages of $300,000, and Ms. Thomas promptly filed her answer. So you added a party, you've according to this, filed an additional claim. So I'm really having difficulty seeing how this is distinguishable from the case at bar.
Let me give a shot at it. I thought my brief was clear, but I'm in trouble right now. It looks like in Crowley, basically everything that happened in the circuit court stemmed from the very same facts of the accident. It was about money. It was about what the liability is. It all
And
came
that may
from
be
it.
correct, but I mean, we've got a new party. We got different causes of action stemming from the same stuff.
Well, I would, not to argue with you, Your Honor, but I would say, asking for more money is not a different cause of action. Adding a new party, maybe that is, but it's basically just another way to get more money.
Well, that's not what the opinion says. It says a second amended complaint filed by the Crowleys asserted an additional claim.
I don't know what that claim is.
I don't know.
Does it say? I mean, I don't have the case in front of me, nor the time to, but.
Well, I'm just reading the paragraph on page, the second page of the Crowley opinion authored by Justice Holder.
I would say this, in Chimneyhill, the appeal was the assessment, the judgment for not paying dues and assessments. That's what it went up as. It would be like Crowley if it had remained that way, and that whatever claim that Chimneyhill was making for more dues and assessments. But Mr. Chow chose to add another cause of action, which was basically, I want to set off in reimbursement for repairs. That was something which was totally new, much different than in Crowley asking for more money. That could have been done then. I mean, apparently they were aggrieved at that point in general sessions. If they thought they needed more money, they would have been aggrieved, and they should have filed a notice of appeal by terms of the statute. In our case, there is no aggrievement. There is nothing that they could do except file a frivolous appeal. The law is usually logical, and the result that Crowley would hold in this case is not logical. And I think the law usually is logical. And I think I put in the brief reasons why the trial judge was right in doing what she did. And let's see, I would like to just add, as far as there's something about in the discretionary costs, there's a $917 bill that was incurred with the property manager, time spent and whatnot. And on that, I would I would refer the court to Southwind Residential Properties versus Ford. It's 2017 case. I'll put that in supplemental authority. And in that case, money was awarded. Actually, it's for collection costs. It's for costs as opposed to discretionary costs. So on that score, I would say it is either harmless error to put it in discretionary costs, or it is agreeing with the results but not the reasoning. But I just, Judge Stafford, I know you and the other judges are going to look very, very closely at Crowley, because that can be really determinative. And I took a lot of effort and thought power looking at that case, and I've continued to look at it for months. And I am convinced that it does not rule this case. And I know that you'll look at it closely. So thank you very much.
Thank you. Right.
Thank you, John. I think I reserved 5 minutes for rebuttal. Now, John, I didn't understand the argument when they made it in the brief, and I don't understand it now. Crowley is Crowley, and it says exactly what it says. And it says that there was a new claim, and there was a party added, and the damages were increased. And it's exactly the same thing that happened here. Crowley stood up when the case was dismissed by the defendant, the appeal, and he stood up and cried, "Foul, I've incurred, I've got this, I've got that." It didn't make any difference. Your Honor, it's jurisdictional. All these arguments about in the brief about de novo, and what's de novo? It's still a jurisdictional matter. The statute is clear, and the Supreme Court case, in my opinion, is crystal clear, and there is no real distinction here factually between these two cases. Now, you've heard Mr. Bloom tell you, well, somehow it was somewhat of a different type, a different claim. And now look, all the facts that had occurred had already occurred by the time of the appeal. The fact that Chimneyhill is somehow saying, well, we're adding a count that we can foreclose on the lien on the assessment lien. So what? Or the fact that now they were always fighting about the roof leak. They were always fighting about whether Chow owes the assessments because of the roof leak. Nothing changed. Nothing. That was, and of course, sitting here today, I'm thinking that was, well, Your Honor, looking at the pleadings from General Sessions Court, frankly, who knows? The pleadings are so sparse, you really can't tell. But I do know this, they had their day in court. All the facts were already in at the time that they heard the Sessions Court case. They're not new facts that were added after that somehow they get to have a new case on. And if there were new facts, they could file a new lawsuit, frankly. It doesn't change the jurisdictional aspect of this. Crowley said, this is a jurisdictional matter. Once the notice of dismissal is filed, that's the end of it. End of game. The court can't go on and pretend like it wasn't dismissed and do things like this court did. And let's talk about that a minute. Since the court had just denied a motion for summary judgment on May 30th on the merits, how in the world could Chimneyhill be the prevailing party in what the court went on and did after it? In my opinion, it wasn't supposed to do, but it went on and did that. Now look, you still have to have a prevailing party, I thought, even under this court's Brunswick case. You have to have litigation that's kind of concluded with a party that wins. You don't just get attorney's fees because you ask for them. I think that's the holding of Brunswick. Prevailing party, the case was over on the merits. The homeowners had lost and the court awarded attorney's fees. We never got close to any of that in this case. In fact, we couldn't get close to it because once Chow dismissed his appeal, he had no right to stand up and do anything in court. It was over. That was the end of the case. And to say, well, no, Chimneyhill can keep on going and just keep on talking and get a judgment, even though, well, you threw in the towel. You dismissed your case. Mr. Chow, you can't even defend here. Really? Well, that's not right. It's just not right. So this is what Crowley said, what it said. The legislation in 2018 after this case did what it did. And it would have covered Mr. Bloom's client if the appeal was in 2018. But that's not what it is. Crowley was the controlling law. And that's that. It's a jurisdictional matter. The case should have been dismissed, affirmed, the dismissal and the judgment affirmed at the point that our notice of dismissal was filed. And that's Crowley. That just is what it is. There's no distinction between it and Mr. Chow's case. It's factually on point in every way. That's all I've got to say.
All right. Thank you, gentlemen. We appreciate your argument. We appreciate you participating with us via Zoom. I want to thank Mr. Hibner, Ms. Dempsey, and Mr. Hibner's staff for working so diligently to make this possible, as well as the AOC technology staff. We will do our best to get you an opinion in this matter at the earliest possible time. Ms. Angie, if you will recess court to the call of the next case, please.
Thank you.
This honorable court is in recess until 3 p.m.